Before we call the case, a couple things. One, the court wants to thank the lawyers for participating in this oral argument by Zoom in these most interesting times. Enables the court to continue to dispose of these cases, which is good for the parties and for the people of the state of Tennessee. If we should have any technological problems, we'll take a pause and Mr. Hivner and the AOC IT people will work through it. Hivner, call the case, please.
Christopher Presley versus Bradley County, Tennessee.
We'll hear from the appellant.
Okay, Your Honor, I'm John Wolf, an attorney from Hamilton County, Tennessee, practicing in Chattanooga. And we represent the Presley people in this matter, the appellants. And basically, what we're contending today is that this was a foreseeable event when on January the 3rd, 2015, Mr. Presley from an elevated place inside the Bradley County Jail decided to leap, and he did hurt himself. It was apparently a self-inflicted injury. But our contention, Your Honor, I know self-inflicted injuries are a little bit more difficult to prove than other types of injuries because, the person who wants to do it is bent on doing it. However, in this case, there were some other circumstances. Unlike the Linkus case, Mr. Presley had been in custody for quite some time with Bradley County. In early December, I think on the 2nd, before his January leap, he had been taken, he was in Moxon Bend. They were checking on his progress there. They knew he was having some mental problems. That's the state mental institution here in Hamilton County, Moxon Bend. And he was there, then he disappeared, then they got him back. And even in late December, when he was back in the custody of the jail, he had some incidents then where they had to take him to the hospital a couple of times. His behavior was erratic, and they finally brought him back, I think, on the 1st of January of 2015. And according to one of the officers there, they put him in B-pod, which is booking. And they were more attentive to him, I think, in that place because that is right there close to where the intake is. And somehow or another, between the 1st and the 3rd, he was moved. And we never quite figured out why he was moved, but he was moved. Then on the 3rd, being where he was, he jumped. But before that, he had been in booking and he was under closer surveillance. Then somehow or another, between the 1st, 2nd, or 3rd, on one of those dates, he was moved to the general population. That's where he was allowed to get into the general population, and that's where the incident occurred. And of course, there was.
Did you have any expert testimony that he was subject to suicidal tendencies?
No, Your Honor, we did not. We know that in the Linkus case, they asked for that. But in that case, there was a fellow, I think, who went into the prison. I think it was somewhere in Middle Tennessee. He was just there for 4 hours. He was there on a DUI. They would have put him in the drunk tank, but they had the meanest prisoner, I think, in the county in the drunk tank. So they had to put him in a visitation cell. And there he, unforeseeable to the folks there, he used the cord there that people use to talk to prisoners to hang himself. And I think there had been a couple of times during that 4 hours where they had taken him to the bathroom and checked on him. So this is a little bit different here, we think, because of the prolonged nature of the detention. We don't think that an expert was necessary. It's self-evident on its face that he was a danger to himself, and they had known this for quite some time, but somehow or another let him back into the general population after on the 1st he was booked into booking, and on the 2nd he was visited in booking according to the affidavit of Herbert Conley. He was visited the night of the 2nd of January by his minister. So for somehow or another, he got into the general population after that when he should have been in booking because of his erratic behavior the whole month before. So that's pretty much what our contention is. And as far as the foreseeability and the expert.
What proof did you have, or did you have any proof to place Bradley County on notice that this person was of danger to himself.
Yes, Your Honor, the records indicate that, I think, from Moccasin Bend. The notations from the police officers, they're not records themselves from Moccasin Bend, but the notations from the police officer in the record, I think from December the 2nd or the 10th, I forget which it was. But anyway, that was 3 or 4 months or 3 or 4 weeks in advance of his jump. And also the other thing is too, it makes notations to his erratic behavior, as do the other records in later December. And I think there's even some indication in the records maybe of January 1st that his behavior continued to be erratic. And that may be why the sergeant put him in booking to begin with on January 1st. And also there's the matter of the missing videotape, which was watched by the chief jailer, Thomas, and then it wasn't kept, even though that was a big event where someone was seriously injured. Somehow or another, he viewed the tape and didn't preserve it. Now, we do have there is something in the record that shows that he, I think from 1501 to afternoon to 1503, he was observed on tape, I think by jailer Peels, and that's in the record too. So that means that the jailer Peels watched him later after the event. He turned the tape on and recorded what he saw, and that was an interlude that lasted from 1501 to 1503. That could have been, since we don't have a second timer on it, that could be anywhere between 61 seconds and 2 minutes and 58 seconds. But for some time before he jumped, he was viewed on video. So again, without the actual tape, it's hard to know whether there was a instance there that provided also further foreseeability to the defendant that this man was a risk of harm. How long he stood there, how long he was there out open, in this manner, where he was obviously trying to hurt himself, or at least on the verge of it, a very concerning matter. I don't know. It could have been as long as 2:59. It could have been as short as 61 or 62 seconds. But again, that's evidence we should have, but don't have. And it's not through our fault that it's not there. It's the fault of the defendant who didn't preserve the evidence. And I think that's raises some serious issues there, as far as whether or not the judge should have been a little bit more hard on that sort of omission, maybe giving us an inference that at least lasted through the time that we presented our proof to the judge.
Counsel, let me ask you, did the record show that the defendant did have him evaluated by who was it, Quality Correctional Health Care?
Your Honor, I'm not sure about that. I really can't give you an answer today to that question. I wish I knew the answer. I don't recall an evaluation by Quality Correctional Healthcare in the record. Maybe there is one and I just overlooked it.
Okay.
I'm sorry. So that's pretty much what the sum and substance of our case, I think, is there was foreseeability. I don't think we need an expert, because I think the proof is so clear that he was a danger to himself because of his lengthy record inside the jail. This documented where he is doing things that are erratic and very detrimental to his own safety, and probably even more than detrimental, as it turned out.
Anything else, counsel?
No, Your Honor.
You have your time for rebuttal. We'll hear from the appellee. You need to unmute your, that's all right.
As much practice as I get at that, I still look like Flo on the Progressive commercial,
So do I.
May it please the court, I'm Thomas LaQuire here for Bradley County this afternoon, obviously. I would like to point out, first of all, that there is nothing in the record, nothing in the medical records, nothing in the jail files, nothing in anything that's been presented here to give any notice to Bradley County or the jail officials there at the prison of any kind of suicidal or self-destructive intentions on the part of Mr. Presley. Mr. Wolf argues that there are things that were unusual. He tends to use the word erratic behavior, which I think is significantly different than suicidal ideations or self-destructive tendencies. And that's what we would need to have here. The case is the Linkus case that he talks about. The other cases clearly show that there needs to be expert testimony. There would need to be some kind of expert testimony to show what the duty of the Bradley County personnel would be and whether or not they breached that duty. In the Linkus case, yes, he was put into a cell where he had an opportunity to have a phone cord and hang himself. But it was stated clearly that that was not the kind of thing that would put them on notice. The fact that he was drunk would not put them on notice that he had any intentions of injuring himself in any way. And so it is with Mr. Presley. The things that we see in his records are that he wandered away from the police officer while he was in Moccasin Bend, which was not for suicide. There's nothing to indicate that that was because of any suicide attempt or any self-destructive tendencies, but he wandered away from a police officer. In the last days before he jumped from the second floor of the jail, it shows that he was in the booking area, they refer to it, for close observation because he had fallen out of his bunk. And he had an incident where he was on all fours and he was drooling. You put that together with the fact that Mr. Presley tended to make a little prison hooch to ease his pain, I guess, from time to time. Those things are not anything to indicate self-destructive behavior. Unusual, yes.
Counsel, let me interrupt you a second.
Sure.
Did Quality Correctional Health Care do an evaluation?
There's not a specific evaluation done around that time as far as any kind of suicidal tendencies. Quality Correctional Health Care is the independent contractor who takes care of the medical. They make the recommendations to the jail personnel based on their regular observations and their regular treatment of whether somebody needs to be kept under special observation. In fact, it was because they were the ones, their nurses noticed this erratic behavior and the unusual activity. They sent him out to Moccasin Bend. They also later sent him just to the emergency room to be checked after this fall. And they are the ones that directed that he be put in booking for a period of time before, a few days before this happened. But at the time that this incident happened, he had been let out of booking. He had been put back into the general population. Again, a determination that was made by Quality Correctional Health Care, which indicates to me they certainly didn't have any concerns about self-destructive tendencies or suicide. It seems to me that with regard to the negligence claim, there's no evidence of a special duty that was owed to this gentleman or that the jail personnel breached that duty in any way. If you know or have reason to know that an inmate has these tendencies or have self-destructive ideas, then you are under a duty. A prison has the duty to put them under heightened observation or to take special precautions. There was no indication of that here. Even if you do have that notice, then you need expert proof to show that that duty was breached. In other words, that they didn't take the necessary precautions. That was what was in the Cochran case. The 1992 case, which is lays the foundation for the legal basis for all these claims, that said that there has to be some notice of self-destructive tendencies and expert proof, as Your Honor, Judge McClarty has stated, expert proof to show that that duty has been breached.
Mr. McQuarrie, what about the video of the incident itself?
I was just about to address that. Thank you, Your Honor. The video, I wish I could explain what happened to it. Unfortunately, I represent a lot of small counties who don't have reliable equipment, whether that's body cameras, video cameras in the jail and those things like that. And it seems to be they're not very reliable. We don't have the video. We were not able to produce that. But I don't think it makes a difference in this case, or certainly doesn't entitle the plaintiff to a default judgment or any kind of implication of negligence. All the video would have shown, there's no question, no dispute that the video would have shown the top of the landing where Mr. Presley walked up and either jumped or climbed onto and fell off of this railway or stairway. That in and of itself doesn't have anything to do with the issue of whether the county employees knew beforehand that he had any suicidal tendencies or that they were under any heightened duty to protect him. All it showed was what is not in dispute, what was stated in Mr. Wolf's complaint, that he climbed the stairway up to the second floor of the jail cell and either jumped or fell over. And we have admitted that. We don't deny that. Everything that has been alleged that the video would show, the defendants have already admitted. The issue is whether or not they had any indication before that, any kind of reason to know that he was suicidal, if it even was suicide attempt. That's questionable in itself. And if we did know about it, what precautions we should have taken about that. So to me, we've admitted whatever the video would have showed, and there's not any difference in what the video would have showed and what we have already admitted and what's undisputed in this case because of the limitations of what it would show. That's pretty much it. There are a couple of things that I would like the court to consider in this case, and that is several things that Mr. Wolf has put in his brief that are not borne out by the record, that he's not made references to the record for support. He's, instead of putting those in the statement of facts, attempted to attach exhibits to his brief in support of those. And this is something that has happened before. And this complaint about the records not being provided to him, they were provided to him, but he has misunderstood or misconstrued what those records showed as far as a release from quality correctional health care to put this man back into the general population. He claims that we had that and refused to provide it to him, or said we would provide it to him and did not. I went back and looked at that deposition testimony this morning, and I was the one questioning Gabe Thomas, the captain of the jail, about what the procedure would be, what the procedure would be if they were keeping a person under observation because they were suspicious of some kind of self-destructive tendencies. And he said in that situation, the quality correctional health care people would be the one who would make the determination whether they would go back into the general population, and they would usually release them to do so. And he said that the man, of course, was in general population at the time this happened, and that he was not under observation because of any suicidal tendencies. Unless Your Honor have a question for me, that's essentially it. I just think it's clear that under the Cochran case and the Linkus case both, that the plaintiff lacks any expert proof on either the duty that was owed to this gentleman and whether or not the county employees breached that duty to cause create liability on their part.
Thank you. Mr. Wolf, we'll hear from you in rebuttal. You need to unmute your computer.
Okay, now is everything okay?
Yes.
All right. Well, here's my response and rebuttal, or my rebuttal and response. There's in the record a January 1st notation from Sergeant Josh Brown, who says on January 1st that evening he took Mr. Presley back into booking. You know, he's in booking there where the jailers can see him and all that sort of thing. Now, on the second, of course, we have the affidavit there of the Reverend who says that he saw him in his cell on the second. Now, the deposition that Mr. LaGuardia refers to, I think, is pages 50 to 55, which is in the record too, and that's the deposition of the jailer, the chief jailer, Gabe Thomas. And in those 5 pages, he said that there was a referral, and Mr. LaGuardia said he would try to get it. Now, he didn't say for sure that he had it, but he said, I think I can get that for you, John. And that's the referral where they would have taken, where the people at Quality Corrections Healthcare would have taken would have written a note or done something to release him from booking into the general population. But that record is not, or that release is not in the record because it was never given to me. And I don't think, that it exists as far as I know. And I think that's what the record shows from our point of view, that there was a change. He went back into the general population after Josh Brown took him to booking on January 1st, and he saw the Reverend on January 2nd. Somehow on January 3rd, he was in the midst of the general population. And there's no proof in the record that Quality Correctional Healthcare released him from booking into the general population. So that's pretty much, that's really all I have to say.
All right. Thanks to both counsel for your briefs and your oral argument today. Mr. Hibner, if you'll adjourn court till the next regularly scheduled session.
This honorable court is now adjourned.